الحمد لله رب العالمين والصلاة والسلام على سيد المرسلين وآله وصحبه أجمعين أما بعد. Chapter number 7, السر الطبي, confidentiality. So we know the medical profession, people trust it. People trust doctors, people usually trust medical personnel. Whether you treat the body, whether you treat the mind, the soul, the psyche, whatever it is, uh, when a patient's coming to you, they're trusting you, right? And during the procedure, during the treatment, uh, the doctor or the nurse would come across, because of their profession, they will come across a lot of secrets. Okay? If you're a therapist, for example, then you're going to come across a lot of personal things about the patient, about other people as well. If you're a doctor, you're doing a checkup, you learn about many things about the person's body, for example, maybe how their life is going on, and really intricate details about it. So, one of the basic ethics of the medical profession uh, is for the medical practitioner for the physician, the nurse, and whatever field the person's working in, is to protect the confidentiality of the secrets that are being revealed to them, that are being opened to them, right? So safeguarding this confidentiality of information is important in medical ethics. It's actually obligatory. However, the problem arises in some cases where, on one hand, it's a moral principle that you should preserve those secrets, that confidentiality. But on the other hand, preserving it might result in detrimental effects. So this is where a medical practitioner could be in a dilemma, is you have to decide whether to keep the information confidential or that you should disclose it, right? Because keeping it confidential would result in another mafsada, in a problem. And so now you have to juggle it around. What do you do? So we made a claim that confidentiality is wajib, right? And this term is used in the medical profession, in which we don't disclose secrets. But what is legal Sharia legitimacy? Well, from an Islamic perspective, the default ruling is that it is haram. Uh, and the Fuqaha actually mentioned that if it results in any form of harm, then it is prohibited. And the evidence for that is, if you look at the Quran, in Surah Al-Anfal, verse 27, Allah subhanahu wa ta'ala mentions, أعوذ بالله من الشيطان الرجيم يا أيها الذين آمنوا لا تخونوا الله والرسول وتخونوا أماناتكم وأنتم تعلمون. O those who believe, do not betray Allah and the Messenger or betray your trust while you know the consequence. Right? So protecting trusts include keeping a secret. Al-amana. Right? So secrets are part of amana. And if you look at the Sunnah, you find different ahadith about this as well. So Anas ibn Malik radiallahu anhu, in a riwayah mentioned in Sahih Bukhari and Sahih Muslim, he mentions that the Rasulullah sallallahu alaihi wasallam confided to me a secret, and I did not disclose it to anyone after that. Even my mother, Sulaym, once asked me about this secret, but I did not tell her. And Jabir ibn Abdullah radiallahu anhu, in a hadith mentioned in Abu Dawud and Tirmizi, he mentions, when a man tells something that looks around, and that when he's looking around to make sure that's not being overheard, then this is automatically a secret. It's entrusted to you, right? So we're seeing that the Prophet Islam gave a secret the same ruling as an item left with a person for safekeeping, which is that you're not allowed to violate this trust. You can't just give it to someone else. You can't expose it, right? So these texts make clear the obligation of keeping secrets and the prohibition of disclosing them. However, as we mentioned, then in some cases, you're going to have to open up, right? And that is also understood by the text themselves. So if you look at Surah Yusuf, verse 26, Allah subhanahu wa ta'ala mentions, قَالَ هِيَ رَاوَدَتْنِي عَنْ نَفْسِي. So when the wife of Aziz Misr, she accused Yusuf alayhi salam uh, for trying to commit adultery with her, alayhi billah, he had to actually mention the whole story. He had to expose what happened in his defense, and it was necessary at that time because if he had kept quiet and didn't defend himself, things would have gotten very bad. So from this, we know that in cases of necessity, it is allowed to reveal confidential information, even if in a medical setting the patient does not consent. Because if it's a genuine necessity, the patient no longer has the right to this information. What are some specific examples for that that's necessary we should know? So whether the disclosure of any confidential medical information is allowed or not is hugely dependent on weighing between the prospective benefits and harms, right? So if the harms outweigh the benefits, or the opposite, if the benefits of exposing a secret outweigh the harm, then it is permissible for you to expose them. Some examples for are number one, confession to a crime. Right, so the patient may confess to having committed a crime that someone else is accused of. If the doctor is confident that the patient is telling due to the effect of the illness, psychological mostly, or under influence of medication, then it is the responsibility of the tabib to divulge this information. And the reason being that in this case, preponderant harm, that is, an innocent person is going to be punished for a crime he did not commit. Right? And so in order to avoid that, the physician practitioner uh, will expose this secret uh, according to the legal maxim of warding off a detriment, taking precedence over thinking about benefits. And what in Arabic we call دفع المضرة خير من جلب المنفعة أو مقدم على جلب المنفعة. So if you have two options, one in which if you have something in which you have both benefits and nuqsan, or some two options in one which you get extra benefits, while on the other you are able to repel harm. Repelling harm comes takes precedence, right? So preventing the punishment of an innocent person is going to take priority over the patient's right to confidentiality. right? So يعني خلاصة is your confidentiality is only respected as long as it is not a source of harm to other people, right? So hence, first and foremost, the doctor should try to persuade the patient to confess his crime. And if he's unsuccessful in persuading him, then he should reveal the information to the authorities. However, he should only disclose what is strictly essential for the task, and not to give extra details, right? Now, although this is going to harm your patient when you expose those secrets, but it's not your exposure of secrets that's the actual reason for the harm. The actual reason for the harm was the patient's crime, right? It's not the result of your direct testimony. It's not the direct result of your testimony. Uh, if he hadn't committed the crime and you would have exposed whatever other secrets, there wouldn't have been that harm. So it's the doctor's only doing what he's responsible for, right? And so whenever the Prophet ﷺ, when he mentioned that la darara wa la zirara, that you shall neither be harmed nor shall you harm, this also tells us that this is not mutlaq. So neither shall you harm is not absolute. It's only in the cases where the harm is not justified. But it is justified, then you will care for that. Some jurists have mentioned that among the situations where it is obligatory to testify is the case where it is feared that the plaintiff will lose his legitimate right because he's unaware that there is someone who can testify in his favor. Right? This is supported by a hadith in which Zayd ibn Khalid al-Juhani radiallahu anhu mentions that the Prophet ﷺ said, "Shall I not inform you about the best of witnesses? He is the one who offers his testimony before he is asked for it. Therefore, if someone possesses testimony which is of benefit to someone else, and the beneficiary is not aware of this, then the witness must reveal this and not conceal it." So again, or this hadith is the other reason that the doctor should reveal that testimony, which is going to protect him from possible legal consequences. Khairan, in any case, um, wherever the disclosure of information would lead to major harm resulting to the doctor or his family, then he must refrain from testifying based on the words of Allah subhanahu wa ta'ala. لا تضار كاتب ولا شهيد. Let not the scribe or the witness be harmed. Right? Similarly, the doctor is not required to cause harm to himself in order to benefit another. So what this last part actually means is if giving testimony is going to result in the harm to the doctor or his family, then he can actually refrain from doing so. In order to benefit someone else, you don't have to necessarily take the harm for yourself. And this could be the case if your patient is, for example, a prominent member of a mafia or the underground world, for example. They have a lot of influence and they can harm you even when you're in jail. That is maybe you could consider maybe not exposing it or exposing it in a more subtle fashion. Or maybe if you yourself are influential enough or have protective measures, then you might want to consider exposing that secret of a crime. So that's case scenario number one. Scenario number two is incompatibility of potential spouses. So, for example, if a man and a woman present themselves for premarital screening, right? And the screening reveals that one of them has a disease, a certain disease, specific disease, that could result maybe in the form of the child being severely deformed. So one of them has a defected genetic material, for example. So the question is, what is the appropriate course of action? Well, the fact that the couple submitted themselves to this testing, it automatically implies that they consent to the results being disclosed to them, right? Or else why would you come to have marital screening? Hence, the doctor should weigh the benefits and harms of disclosing or not disclosing. So, if in the case where he decides to disclose information, it is enough for him to just say, I advise you not to get married. You don't have to reveal everything, every specific details of it. Just saying that my advice is that you should not get married is enough. And the evidence for just confirming to that is mentioned uh, can be taken out from the Quran. Allah subhanahu wa ta'ala mentions in Surah Al-Furqan, verse 74. والذين يقولون ربنا هب لنا من أزواجنا وذرياتنا قرة أعين وجعلنا للمتقين إماما. Those who say, Our Lord, grant us from among our wives and offspring comfort to our eyes and make us an example for the righteous. Now, how does this ayah relate to the mas'ala we discussed above? Well, the verse indicates that the believer wants their children to be righteous and to be an asset to the life of this world and religion. And if your child is born with a major deformity, then that purpose in which you're asking Allah subhanahu wa ta'ala for children might not be fulfilled. Right? And you can imagine the difficulty parents face when they have a child with such defects, maybe Down syndrome, take for example. It becomes very difficult for the children. Yes, there's extreme ajr for the parents in it, but at the same time, it is a very challenging task. So if in premarital screening, these results show up that maybe that this zivaj is not suitable because it might result in physically or mentally deformed children, then you might consider not getting married. Or maybe not having children if you were deciding as a married couple to have children. And it's okay. Also, Abu Hurairah radiallahu anhu, in a hadith mentioned in Sahih Muslim, he mentions that I was with Rasulullah sallallahu alaihi wasallam, and a man came to him and told him that he has married a woman from the Ansar, or he actually wants to marry a woman from the Ansar. And so the Prophet ﷺ, he asked him, have you looked at her? In which he said, no. So the Prophet ﷺ told him, go and look at her, for there's something in the eyes of the Ansar. Right? So this hadith indicates the importance of knowing about potential defects in one's fiance or fiancée, and that someone who has knowledge of such a defect should inform the other party by way of advice. So give them nasiha. So don't expose everything if you know about them. Maybe tell them that that person has a bodily defect which you might not be able to handle or you would not like. Or maybe that person has a character deficit that is not going to gel with you, that's not going to suit you. So through nasiha, just limit it to mentioning that they have a problem which is not going to suit you. You don't have to delve too much into that. The third thing is that remaining silent about the defect of potential is tantamount to deceiving the other. So it is likely that if one of them had known of the exercise of this problem, they would not have agreed to marry that person, right? So there's some problems that we might have, but we don't know them. And they're not exposed to us without proper screening. But if you do have a defect in your body, in your genes that you know of, you should tell your potential spouses that, hey, I have this problem. Are you okay with it? If they're willing, they'll go on. If not, then you can't do anything about this. An example of that is when one of the spouses suffers from a disease that can be transmitted through sexual contact. So here, applying the maxim درع المفاصل مقدم على جلب المصالح, that repelling harm takes precedence over bringing benefit, right? And the harm of transmitting the disease to the other spouse is more serious than the benefit of not disclosing the secret. Therefore, the doctor should inform the other spouse of the nature of the disease and the harms that result from it. And he should also explain to both of the spouses that neither of them is allowed to disclose the defects of others. And to the contrary, they should conceal such information because it's common courtesy. And also that it is the hukum of Allah subhanahu wa ta'ala and his Nabi alayhi salam. Now let's come to the third case study in which medical confidentiality can be breached, which is shubhatul zina, a suspicion of zina. So in cases where the doctor is almost certain, not completely. So let's say you have zan ghalib, and based on medical grounds that zina has been committed, it is obligatory for him to remain silent and not inform the other spouse, right? Over here, it is obligatory that he remains silent. And in this case, he's not going to divulge medical secrets, right? For the same reason that warning off detriments and harm takes precedence over bringing benefits. And the Sharia emphasizes the protection of lineage. And so precaution should be taken for this, and it is to be affirmed even on weak grounds. So this implies that paternity cannot be negated without irrefutable proof. So just having shubha of zina have been committed is not sufficient, right? So rather than leaving a child fatherless, uh, the doctor should keep quiet because he doesn't have irrefutable proof. It's only his assumption. Sure, he has medical basis for that, but in Sharia that is not sufficient to harm the possible lineage to a child. The evidence of that can be found in a hadith mentioned in Bukhari and Muslim. So Abu Hurairah radiallahu anhu, he narrates that a man came to the Prophet ﷺ and mentioned, Ya Rasulullah, ولد لي غلام أسود, that a black boy has been born to me. And what he was trying to say is that I'm wheat colored and yet I have a black boy. How is that possible? My wife is also wheat colored, which in other ways, he's basically saying that it is possible, both of us being wheat colored, that our boy should be black. So he had the suspicion that his wife, Billah, might have committed a crime. The Prophet Islam asked him, هل لك من إبل? Do you have camels? And he said, yes. And he asked him about other colors, and he said that, well, they're red. And then the Prophet ﷺ asked, هل فيها من أورق? Are there any gray camels among your red camels? And he said yes. Then the Prophet ﷺ asked how? Like, if all your camels are red, how do you have some gray camels beneath them? And he gave a reason. Perhaps it was brought out by ancestry. And so the Prophet ﷺ replied, uh, the same thing. لعله نزع إرق أي لعل ابنك هذا نزعه, that maybe your boy example brought it out by ancestry. Maybe there was a gene in either your side or your wife's side which had a dark skin color in it. It didn't show up in you, it didn't show up in her, but maybe by the combination of your genes, maybe one of you transferred your black genes to the other, and that manifested, and that can happen, medically speaking. So maybe that's the case, and not that something wrong is in the works here, right? So it's understood through this hadith that the son is attributed to the husband, even if they differ in com- complexion. So white and boy is black, vice versa. So the color doesn't really matter. It's not sufficient grounds to refute a lineal legacy, and it's neither the grounds to have suspicion. So you cannot deny the husband cannot deny paternity merely because there's a difference in complexion, because of the possibility of it being genes in play, his own genes, which were latent and now they've become dominant. Another similar case would be if the spouses were white while the boy is black, or vice versa. The spouses are both black and the boy turns out white, right? So this hadith, khulasa, it is telling us to be cautious about negating paternity, and that paternity should be upheld and established as long as there's the slightest possibility of it. What that also tells us is that one may not rely on medical laboratory analysis in such cases because of the chance of error in these results. Moreover, the Sharia strives to attribute paternity to the husband and to conceal people's sin. Exposing someone else's sin is not going to get you anywhere. So the harm of that, obviously, if someone learns out that Nauzubillah, their spouse committed a crime, an extramarital affair, 9 out of 10, they're not going to want to stay with them anymore. And what if they had previous legitimate children? All of their lives are going to be severely affected as well. And this case, there's only an ihtimal. Maybe it had happened and maybe it not. And so until you have concrete proof, the Sharia does not allow for it to be considered. So the Lajna Da'ima, the Permanent Research Committee, was asked about a woman who has committed zina while being married. They replied, if a woman commits zina and becomes pregnant, then the child by default is attributed to her husband, based on the sound hadith, al-waladu lil-firashi. But if the husband wishes to deny paternity, they may do so through the process of mula'ana before an Islamic judge. So there's a whole process where if the husband suspects his wife of committing a crime, they do mula'ana. The details of mula'ana are mentioned in the books of fiqh. And the last case study that we have is about contagious diseases. So if the disease is contagious and treatable, but the patient is refusing treatment, then the public interest dictates that his confidentiality should be breached by reporting him to the relevant authorities, either for them to enforce him to go undergo treatment or appropriate preventative and immunization measures can be adopted. This is again because the same principle درء المفاسد مقدم على جلب المنفعة. And also because of the legal maxim that تقدم المصلحة العامة على الخاصة, that public interests take precedence over private interest. And so any action that is in the public's interest is certainly a goal worthy of pursuing and desirable act of rahmah, even if it results to harm to some individuals. So what is the khulas and the crux of ahkam about medical confidentiality? Well, according to the resolution of Al-Majma' al-Fiqh al-Islami, the International Islamic Fiqh Academy, the following resolution was made for medical professionals regarding confidentiality. Uh, Number one is confidential information. For these purposes, is anything that is conveyed by one person to another with a request to keep it secret. This includes things where the surrounding context indicates a desire for confidentiality based on customary norms, as well as private information relating to an individual and his demerits, which he would dislike people knowing. So he doesn't have to explicitly tell you that keep this secret. If by norm and custom it is considered secret, it is secret. And if it's something that's normally hidden and you would expect to remain hidden, you can also not divulge those things either. Number two, such confidential information is considered a responsibility in the hands of the person entrusted with it, right? And this is in commitment to the teachings of Islam and also as dictated by the principles of chivalry and ethics of proper interaction. Number three, the default rule is that revealing confidential information is prohibited. To reveal such information without a valid justification is Islamically liable to censure. Number four, from the first shiq, the obligation of safeguarding confidentiality is heightened for those who work in professions where in revealing confidential information would lead to undermining the ethical foundation of the profession, such as the medical field and especially the psychology field. Vulnerable people who are in need place their trust in the medical professionals with a view to obtaining sincere counsel and assistance, such that they disclose to them all information that may help them to discharge these critical responsibilities. Right? So this includes secrets that they would not have revealed otherwise or to any other person. This is the general rule. Uh, Now, number two exposes the exceptions to these rules. An exception is made from obligation of maintaining confidentiality in cases where keeping it is going to result in greater harm for the patient than actually revealing them, or where disclosing the confidential information will result in benefit that outweighs the harm of concealing it. And such cases can be divided into two categories. Number A is cases where it is obligatory that you reveal confidential information. based on the principle of commission of lesser evil in order to alleviate the greater evil. When you have two evils, you choose the lesser in order than the greater one. And also through the maxim of achieving public interest in which individuals might suffer harm. And these are two cases. Those involve preventing harm to society, like in the case of al-amraz al-mu'diya, contagious diseases, and those which involve preventing harm to an individual. For example, in the case of medical screening for sexually transmitted diseases. Then there are cases in which it is permissible to reveal confidential information and not necessary in order to achieve public interest, in order to avert public harm. In such cases, it is obligatory to adhere to higher objectives of the Sharia, namely the maqasid, right? Protection of faith, life, intellect, property, and lineage. Now, even in cases where it is obligatory to reveal confidential information, must be explicitly specified and explained to the patient. And similarly, it should also be very clearly specified for the doctors as well. So we should have an ethical manual for medical practitioners in which cases where it is necessary that you divulge secrets should be mentioned because it's not always an easy task in making the judgment of whether you keep the secret or you reveal it. So they should be clearly explained and exhaustively enumerated in the codes of practice for medical and other professions. And this should include detailed specification as to the manner in which the confidential information would be disclosed and to whom it can be disclosed. The relevant authorities should educate all involved personnel about these situations. And this is a summary of the resolution passed by the Islamic Fiqh Council. Allahu Alam bisawab. Chapter number 8, and this is a very short chapter, and this is about negligence and liability. So let's first discuss, we're going to discuss five things here. Number one, what is the meaning of liability? Number two, what are the components of liability? Number three, the liability of the doctor. What does it mean? And what are the types of it? Number four are in the conditions where the doctor is or the medical professional is no longer liable. And number five is the athar, the effects and the results that manifest because of this liability. So first of all, liability, linguistically, it means the state of being responsible or accountable for something. And you have two words. You have mas'uliyah, that is responsibility, and you have azlaman, which is negligence. Right? So responsibility is the state or fact of being responsible, answerable, or accountable for something within one's power, control, or management. Negligence for purposes of law is defined as the failure to exercise the degree of care that in the circumstances the law requires for the protection of other persons or those interests of other persons that may be injuriously affected by the want of such care. Then you have zaman, practice, and is defined as careless, wrong, or illegal actions by someone in our discussion, the doctor, who is performing a professional duty. And liability, for law purposes, is defined as it is a broad term including almost every type of duty, obligation, debt, responsibility, or hazard arising by way of contract, fraud, or statute. And in this context, typically involves the doctor who is guilty of malpractice being judicially compelled to compensate the damage that he's caused. This term is known as zaman in the language of fiqh. What are the elements of liability? أركان المسؤولية الطبية. Well, the first one, so how can we establish malpractice? How can we say that malpractice has taken place? So there are three essential elements that should exist. So element number one is as-sa'il. That is the person who has the official right uh, to take the doctor to the judge. Doctor and his accomplices, assistants to the judge. Number two is al-mas'ul, the defendant who is responsible or who's being accused of malpractice, either be the doctor or the organization that is being sued. And number three is masul anhu, the act of medical malpractice involving injury or damage to that person caused by the doctor or his assistants. So obviously you need the patient who is suing the doctor or the hospital that is being sued, and the reason why they're being sued. Only then can you legally proceed with a case of malpractice. Now, there are four causes of liability in the medical profession. Number one is negligence. And by negligence, we mean the negligence in following scientific principles and standards of the profession, which are regularly and customarily followed in theory and practice by physicians, and which all physicians are required to be aware of while practicing their profession. The scientific knowledge is of two sorts, foundational and novel for novel medical issues. The knowledge should be issued by a reputable organization, such as medical schools specializing in medical research, or you have medical journals for that as well. And that novel form of medication treatment that like I mentioned, should be issued by reputable organizations. Non-compliance to such knowledge and ethics by medical professionals might be either on the theoretical or practical or both. All three kinds. So doing the kind of ilaj which is not necessarily known or not. However, this manual is probably written considering the Western mode of health in mind. So this does not place any value to Eastern forms of medication, also alternative forms of medication, uh, which is a legitimate source of treatment, although not considered by the pharmaceutical ideology of the West. And so the fiqh over here, in my suggestion, should be revised to include that as well. So someone trained in Eastern medicine, for example, and they're known to have done that, they should not be held accountable if they do not follow the standard hospital procedure because the hospital does not actually sanction their practice for the most part. In some places and areas, they do in some capacity, but in their profession, if it's something that is not allowed and they do end up doing it, then this too would come under this. But it should not be a one size fit all instructional manual for the different kinds of medical treatments that we have. This is, in my opinion, that I would say someone in the medical field should be able to make a better judgment. So anyhow, first was negligence to follow these issues. The second is al-khata, error, which is basically something that the person did not intend to do. So although there's no ithm, there's no sin in it, because you can't be held accountable for a mistake that you made. There is, however, a liability in it. If you end up harming someone, you have to pay the damages. And number three is jahl, ignorance, whether it is partial or total. So you were ignorant of the required scientific knowledge, and you end up doing something. A general physician, for example, ends up performing a surgery, although they didn't have the required expertise or knowledge about how to perform the surgery. And number four includes al-i'tida, which is wanton negligence, which is deliberate act of crime. So the doctor deliberately commits an act that causes harm to the patient. And this last one is the most serious, right? And usually this fourth point is difficult to prove without a confession. But sometimes strong contextual indicators, such as the existence of enmity between the doctor and patient, or if the doctor has been previously accused of being threatened by the patient, for example, these cases might reveal that as well. They're not 100%, but kind of gives you a shot towards it. Now, the third mahwar of discussion is the liability of the physician. And a doctor, they carry a great deal of responsibility, and they're liable both morally and religiously as well. So they're religious, morally, and uh, they're sorry, liable morally and religiously, and also they might potentially be liable criminally. And the evidence for this is in the hadith of Amr ibn Shu'ayb عن أبيه عن جده, for a hadith that is mentioned in Sunan Abi Dawud. So the Prophet Islam mentioned, من تطبب ولم يعلم منه طب قبل ذلك فهو ظالم. Whoever practices medicine but is not known to have prior medical experience, he is liable. So if I started practicing medicine today and I ended up harming someone, I would be liable because I'm not known as a doctor. So based on this, a doctor who acted out of ignorance or i'tidaa, deliberately harms the patient, is held liable for whatever damage he causes, and in some cases may be subject to qisas or ta'zir or financial compensation, whatever the court decides. Now we're talking about the types of liabilities, right? So we mentioned that the doctor has two types of liability. First, he has the general moral liability or responsibility. And this liability of the physician deals with the ethical aspects of the doctor-patient relationship, like confidentiality that we discussed previously. It relates to a set of ethical principles required of all people in general, except that because of the sensitive case of the situation, its importance explodes and it becomes highlighted. These principles include truthfulness, sincerity, maintaining confidentiality, fulfillment of contractual obligations. In cases where the physician errs, In one or more of these moral aspects, he is considered liable if the error directly or indirectly leads to harm. In such cases, the physician is held accountable for the consequences if he had no legitimate justification for violating the ethical precept. The second type of liability is professional liability, and this deals with practical aspects of the medical profession. Such liability arises when physician violates one or more of the agreed upon principles that are customarily accepted within the profession, and this directly or indirectly leads to harming the patient. The professional contract between the doctor and the patient requires the former to comply with the recognized principles of their profession. Thus, it is implicitly stipulated that he be knowledgeable about medicine and as adept and skillful a practitioner as much as possible for them. So not only should the doctor be knowledgeable in their field, they should also have sufficient practical experience for this. So medically speaking, in terms of responsibility, if a physician demonstrates lack of knowledge or competence, and this results in harm, whether directly or indirectly, then that person is medic. This is a situation of medical liability. Example of this is, for example, during surgery, the surgeon leaves scissors or a gauze in the patient's abdomen, and he will be liable for the consequences. If he did this intentionally, then he's criminally liable. And if the patient dies, the surgeon could be subject to a requisite criminal penalty, either qisas or payment of blood money. And if it was not intentional, then his liability is civil as opposed to being criminal. And in this case, he is required to pay compensation for the damage. Now, I've talked about doctor liability. What are the conditions in which liability no longer exists, in which the doctor is no longer liable? Well, condition number one is al-idhn al-am, you have general authorization, where the ruler or government has authorized the doctor to practice his profession, right? So now this usually is taken in the form of a license granted by the Ministry of Health to the doctor, permitting him to practice medicine, right? And this is because the Sharia stipulates that the one who practices medicine must be knowledgeable and competent. So when you have a license, it means you have the authority to practice, and the one who does not have a license does not have the authority to practice. So you should have a Islam, you should have a license to practice medicine. That's condition number one. Condition number two is uh, al-idhn al-khas, private authorization, wherein you being a doctor, you have to have consent. And so if the patient or their guardian give you consent that go ahead with the treatment, now you have gained private authorization. And so if the physician takes it upon himself that I'm going to practice medicine, even though I don't have consent, they will be liable. Obviously, in the chapter of consent, we discussed there are some scenarios in which private consent is no longer a required condition because it becomes necessary to perform treatment. In those cases, obviously, private consent would not be one of the conditions that we're talking about here. And we'll mention there are two exceptions to this obligation. Critical situations where the patient's life is in danger, his or organs or one of his limbs too, and he's unconscious. This can happen during wars, natural disasters, or serious car accidents, for example. The same would apply if the patient is not unconscious. Like the condition is such that he's incapable of giving consent, and you don't have access to their guardian or proxy, right? And usually doctors would face the situation where quick surgical intervention is needed, especially in the ER, such as cases of appendicitis, where the appendix might you expect it to rupture, right? And so you quickly have to perform surgery. You don't have time to ask questions. And second scenario would be situations where public interest takes precedence. So someone suffering from a contagious disease is adamant that I'm not going to quarantine, that I'm not going to take medication, then it can be forced upon him, even though he does not want it. Third condition, after Ibn al-Khas, uh, is respecting scientific standards of the profession. So jurists have stipulated that those who diagnose diseases, prescribe drugs, or perform surgery must be proficient in their profession, have a high level of knowledge, and practice in accordance with the standard protocols of the profession. So therefore, a doctor is not allowed to practice if he's not academically competent and experienced. So cost department uh, treatment is a part of this. So an orthopedist should not be performing a heart surgery. And a heart surgeon should not be acting as a gynecologist because they don't have training in those respective fields. So follow the specialization that you've taken in. And lastly, you have qasdul ilaj, acting with the intent to cure, i.e. the doctor's motive. That is important. So their motive should be to cure the patient and to cater to the patient's interest. And so it is not allowed for the doctor to do anything to the patient with any other motive, such as scientific experimentation that is not in the patient's best interest. So the doctor must be well intentioned and someone the patient can depend on. You should not prescribe a medicine that will be harmful to them. If the doctor has malicious intent and has other motives for practicing the profession, such as harming the patient, then the doctor is criminally responsible for his acts because of his intentions. The last discussion that we have is what are the consequences for a physician who is found liable, who has breached uh, these standards. In this case, the fuqaha, they agree that a physician is not held liable for harm suffered by the patient if the physician was professionally competent, acted with the consent of the patient or his proxy guardian, had the intention of cure, had his license and was not negligent. The fuqaha are also in agreement that a physician is held criminally liable if two criteria are fulfilled. That is, A, he transgressed the bounds of his authorization, and harm resulted in that. So, in the cases where a physician is found liable, or not just a physician, any medical professional, he will be subject to one or more of the following consequences. Number A, financial compensation. This includes diya, blood money, and arsh. And arsh is a compensation awarded by court for injuries other than death, in accordance with the amounts and procedures stipulated by the Sharia. Financial compensation is due to in case of errors resulting from negligence, carelessness, or failure to take necessary precautions. Another form of punishment is ta'zir. This is a penalty whose magnitude and nature are not specified and left to the discretion of the judge. In case where willful transgression is proven, right? So ta'zir can only be compensation can be in cases where transgression was willful or unintentional. Ta'zir can only be in the cases where it was intentional, where harm to the patient was intended by the medical personnel. And this could include barring the physician from practicing medicine, whether this is by suspending their license uh, or restricting their license. So you can suspend it for a period of time or revoke it completely, or you could restrict their practice to a certain field or a certain state. The third, these two are more like the worldly uh, responsibilities or worldly repercussions breaching, uh, of being liable. The more religious punishments for that is atonement by fasting, right? So in the case you accidentally end up killing a patient, you're required by Sharia to fast 2 months consecutively. And in cases where it was murder was intended, then qisas is going to take place, and that medical professional uh, can also be put to death. Now, the resolution by the Al-Majma' al-Fiqh al-Islami, Islamic Fiqh Council, it's as follows. Number one, medicine is an involving science and art that aims to be beneficial to humankind. And thus, the physician must realize that Allah is watching him while he is working and must discharge his duty with sincerity in accordance with scientific and technical standards. Number two, the physician will be held liable if harm ensues to the patient in the following cases. Number A, if it was intended to cause harm. Number two, if he was not competent in medicine or any of the subdisciplines of the act he undertook. Number three, he was not authorized by the requisite official authority. Number four, if he undertook the operation or treatment without the permission of the patient. Number five, if he deceived the patient. Number six, if he committed an error which someone of his standing should not fall into, the kind of which is not tolerated by the professional standards, or if he has been neglectful or careless. And number seven, if he breaches the patient's confidentiality without a valid reason. And number eight, if he refrains from performing his medical duty in emergency cases. Number three on the agenda is on the resolution is that the physician and anyone in a similar position will be held criminally liable in these cases if the conditions for criminal liability that we've discussed are satisfied, except in the case of error. In the case of error, they're not criminally liable unless the error is actually very serious. In that case, you can have monetary compensation, you can't do ta'zir. Number four is if a single medical operation was performed by an integrated medical team, each member of this team will be liable for his error in accordance with the fiqh maxim. If one is faced with direct infliction of harm as well as the indirect precursors of harm, then the direct perpetrator bears responsibility unless those unless the person whose actions were precursors is more deserving of being held responsible. The team leader will be held jointly responsible for the actions of his assistants if he erred in directing or supervising. And the fifth thing was the medical institution, whether it's public or private, stands liable for the harm if it was negligent in its obligations or if it issued instructions resulting in harm to the patient without justification. Wallahu ta'ala a'lam bis